Kia ora koutou. Welcome everyone. I'm Janice Mackay, your host, and I'm the Welcoming Communities Advisor for Ashburton District Council. Our panellists for the webinar today is Jane Argyle-Reed and Jane Fowles. Jane Argyle-Reed is from Argyle, Welsh, Finnigan, and Jane Fowles is from Compliance Partners. Together they will share an overview of employment matters relating to COVID, from restructures to amending pay and all the good faith that goes in between. They will also cover some tips for flexible working arrangements, as well as an update on legislative changes in the first half of 2020, such as minimum wage. They will cover off some key points about what Level 3 looks like in relation to keeping people safe and healthy as we manoeuvre a return to work. In regards to your questions, please try and keep them general. Our panellists won't be able to answer any questions that are too specific. If you have a question that is specific, please ask Jane and Jane directly outside this webinar. Also, to keep the presentation from running too long, they will reserve answering your questions until the end of each of their sections. So please, we also ask for your patience. If we run out of time to answer your question, we will endeavour to answer it offline. Now, a bit about the two Janes, if I may. Jane Argyle-Reed is a partner at Argyle, Welsh, Finnigan. She received her primary and secondary education in Ashburton before attending Otago University, where she studied law and history, graduating in 2004. Since then, Jane has worked in the Dunedin and Christchurch offices of a large South Island firm before joining AWF in April 2009. Jane has wide experience in employment matters and has developed a significant practice in relationship property matters and dispute resolution. Jane Fowles is Principal Advisor and Manager at the Ashburton-based advisory company Compliance Partners. She specialises in HR and H&S advice for small to medium businesses. She is listed on the HAS-ANZ register and currently holds the position of Risk and Assurance Manager for the New Zealand Institute of Safety Management. These webinars were put together to help build community resilience, showcase a snapshot of our local expertise, and to spark ideas and connections. Please feel free to send your questions to the panellists either in the chat box, or if you'd prefer your question to be anonymous, feel free to use the Q&A box. I'll hand over now to you, Jane and Jane.
Since 1894, we've had an organised system of employment law. And since 1894, the obligation to treat each other, employers and employees, with good faith has been the most important employment issue. So the requirement for good faith lies at the heart of the employment relationship. Under common law, and so before 1894 it was implied, but now through the law it's given a statutory requirement. And good faith means that we must treat each other directly or indirectly in good faith, and you must not do anything to mislead or deceive each other. In terms of good faith, broadly speaking, it requires employers and employees to act honestly and openly towards each other and without any hidden motives, to raise issues with each other in a fair and timely way, to work constructively and positively together, to provide each other with relevant information ahead of when it's needed and as soon as possible. All information given should be carefully considered by both parties. Good faith requires that you must be fully honest with each other, to raise concerns or issues as soon as possible and respond to these, to keep an honest and open mind with each other, to listen to each other and be prepared to change your opinion about a particular situation or behaviour, and to treat each other with respect. All of the above bullet points are set out in cases which have been through the New Zealand employment court system. And I know that I'm going on about this, but good faith is just so crucial to an employment relationship. The minimum rights and entitlements in terms of an employment relationship are set out in the Employment Relations Act and in other statutes such as the Holidays Act, the paid parental legislation, and so on. You can change the employment law situation by way of an individual employment agreement, but the minimum terms and conditions in those individual employment agreements must comply with the law. And the employer and employee may not agree to any less favourable conditions as is recorded in the law. So for example, in terms of your annual leave requirements and entitlements or sick leave, bereavement leave, etc., it must comply with the Holidays Act. It's also crucial to remember, and I've been coming up against this situation more and more when I've been talking to particularly employees, it seems that people still aren't complying with the legal requirement that you must have an employment agreement. As an employer, you can get fined by the Department of Labour Inspectorate for not having an employment agreement, and you can also receive penalties for not having all of your documentation up to scratch. And that includes wage records, time records, having accurate records of what each party's annual leave entitlements are. So just another reminder in terms of how crucial all of that documentation is, especially at a really stressful time such as we're going through at the moment. One question I've been having a lot about at the moment is flexible working arrangements, particularly in light of the COVID situation we've got. The existing situation, which was negotiated between employers and employees, was recorded as part of the Employment Relations Act in 2007. So I've just set out on the slide that's in front of you now the very clear requirements in terms of flexible working relationships. It's very clear in the Act about what a request for flexible working arrangements means and what it must say. And there's also really clear requirements in terms of how an employer must deal with a request. The commentary that I've received in terms of this is that employers will need to deal with these kind of requests more and more going forward in terms of people's flexibility around where they're working, not only when we get out of the level 3 situation, but also going forward. People's circumstances are going to continue to change and people are under a huge amount of stress at the moment. So it's really important to negotiate any change of arrangements in good faith. There's been some employment law changes that have happened recently. The most recent, of course, is, and it's been pretty well documented, that on the 1st of April 2020, the adult minimum wage increased from $17.70 an hour to $13.90 an hour. An adult worker is defined as those aged over 16 years and who's not on a trainee wage. The minimum wage for starting out workers and trainee workers has increased from $14.16 to $15.12 per hour. The increase in the minimum wage will have a huge impact now, even more so, on small businesses and those trying to enter the workforce. In terms of the governments have been quite public prior to the COVID situation about their wish to increase the adult minimum wage to $20 per hour in 2021, but who knows whether that will continue to be the case. Care needs to be taken, particularly when dealing with salaries and those people on changing shifts. I've had a number of discussions leading up to the 1st of April 2020 around what minimum wage looks like for example, dairy farmers where their staff are on shifts, and they need to make sure that across the board the salary reflects what the minimum wage needs to be. So you need to be really, really careful when you're doing a calculation around what hours of work are on salary and whether you are actually complying with the minimum wage requirements. And if you need to do some adjustments, then that needs to be the case in terms of your working situation and the minimum wage requirements. Some more changes that are coming up in terms of the legal situation is, I'm just going to touch on this, but paid parental leave is increasing from the 1st of July 2020 to 26 weeks in terms of paid parental leave. I obviously had my children at the wrong time because it was only 14 weeks in those days, but I'm trying not to be bitter. Another change that occurred last year, which I'm just going to remind you about, is domestic violence leave. This is a very sensitive subject for all of everybody that is concerned in terms of this, and should always be handled with care and kindness by employers. Domestic leave provisions should be in your employment agreements, And when employees come to you, or indeed their family members come to you looking for assistance, then as an employer you must treat that situation with discretion, kindness and compassion. The legal requirements in terms of domestic violence leave are clearly set out in the legislation, and it's really important to have the fact that there is domestic violence leave included in your employment agreements, so that when employees come to you, the legal requirements are set out in their employment agreements themselves. So against that background, I'm now going to just talk to you in terms of the current situation around COVID. So the slide that I've prepared is very clear that your primary source of information should always be the government website, covid19.govt.nz. That is regularly updated and updated in terms of particular industries and what each level means in terms of your particular industry. It's the government's way of communicating with everybody about the status and situation in terms of COVID. The MBIE, or Ministry of Business, Innovation and Employment website also has a huge amount of really helpful information and resources on it. So I can encourage you to have a look at that website as well. The MBIE website sets out requirements in terms of how to deal with people, as I said, who are wanting flexible working arrangements, and also has information about, for example, annual leave entitlements, and all of that kind of information is on that website. It's a fantastic resource, and I can't speak highly enough of having a look at that as well. In terms of dealing with people on your staff and as employees and dealing with your employers, communication is the key in terms of processes. We need to remember that the legal processes that are in place and have been in place for many years still need to be followed in terms of this lockdown situation. It's crucial, even more so, that the process is followed correctly. Jane Fowles is going to talk about restructuring and redundancy processes, but I can't speak strongly enough for the fact that the process in terms of changing any form of employment relationship still needs to be followed, whether that's changing the number of hours that staff are working, whether that's changing the amount of wages in terms of the hourly rate, for example. That information still needs to be processed correctly. So the process that still needs to be followed is you need to give or be given information about how the employment situation is going to be changed. That needs to be a written proposal. So whether it's that you're being communicated with by email is probably an easy way of communication in today's environment. The employees need to have time to consider that proposal, and that needs to be in light of the current situation, probably longer than you would ordinarily give that time. The employees then need to be given feedback around the proposal and feedback from their employer, and the employees need to have the decision given to them. So in terms of your obligations, as I started with, the first obligation to each other is always to act in good faith. And you must remember those duties to each other and remember to be kind. Jane Fowles, I think it's your turn.
It is. We do have one question actually that just popped up that I'm just going to throw out there now, just because it is about what you were talking about before, Jane. Where is a place to get an employment agreement from, hypothetically, if you needed to sort of tick that off?
There are lots of fantastic resources. For example, for employers who are farming, the Fed Farmers have an individual employment agreement database, and the MBIE website that I spoke about before has a huge number of resources, but it's always important to have a really good critique of those employment agreements because sometimes the law changes so rapidly. So for example, I've just mentioned before the domestic violence leave, and so it's important to make sure that you're keeping up to date with what those legislative requirements are. And of course, a little marketing blurb, I suppose, make sure your lawyer has a look at it, or your handy HR or health and safety advisor.
I'm not going to disagree with that. I think there's also an employment agreement builder that you can sort of look at on MB as well. But I would definitely, if you're going to build one yourself, definitely try and get that run past somebody who might understand the law, etc., a little bit better. I'm going to move on now to restructure redundancy, but just before we do that, we do have a little poll with some questions to ask you to see, I guess, just to get a bit of a feel for where some of you are at. So crossing our fingers for technology here, I think that Janice is going to launch a little question, which has just hopefully come up to all of you. So the first question is, have you changed your employees' hours or pay during level 4? So this is anonymous, so no one will see what your answer is, I believe. Janice will jump in if I'm wrong there, but I'm pretty sure you just clicked yes, no, and then it's just confidential. So we'll just leave it a couple of seconds, and then hopefully it will pop away. I have to say, I don't know if anybody else, but I've been having a crash course in Zoom for the last 4 weeks, and I saw a really good terminology from the University of Waikato and the Faculty of Maori Sciences, calling it a Zui, which is a hui plus Zoom equals Zui, often punctuated with children popping into the background. Cool, so the answer's up on the screen there, hopefully you can see that. So we've got about a 60-40 split between yes and no. Cool, we have a couple more questions a bit later on, which we'll just sort of launch after I've done my little spiel.
I can see another question that's popped up on the screen. The question for me is, why do you recommend to take a longer time frame for consultation? And the answer to that is because everybody's under a lot of stress at the moment, and I just think that in terms of people's reactions and people's state of mind at the moment, it's really important to consider people's mental health and mental well-being, and that's the reason why I'm suggesting that consultation periods should be longer than they ordinarily would be.
Cool.
Hope that answers the question there.
So I'm going to actually, that's a nice segue for me to talk a bit more about restructure and redundancy. So I'm going to put a bit of a blanket sort of comment over this. This is very much your basic structure when it comes through how to run through a restructure redundancy process. But the caveat is that every single restructure and redundancy is different. I say that because unfortunately over my years of doing HR, and I'm sure Jane will agree, they're never quite all the same. So I do think it's really important to still emphasise here that you do seek advice as much as possible, even if it's just someone to read over a letter before you crack on. The term restructure has some different meanings. So often when we think about restructure redundancy, we think about simply the fact that we are letting people go. That's kind of where our minds go to. But restructure is a term on its own in the sense that that can include changing hours, changing positions, disestablishing positions. It's basically a really broad word in terms of I'm going to change the way somehow that my business operates. In some cases at the moment, that can also include wanting to change people's pay rates or hours for temporary measures as well. Anything that is written into your IAA or your employment agreement as an individual term and condition cannot be changed without mutual agreement or without consultation. So I've heard a few horror stories, I guess, over the last 4 to 5 weeks of someone saying, well, we're just going to pay you 80% without any real good faith or communication. So these steps that we're going to work through are all underpinned by what Jane spent a lot of time talking about in terms of good faith. I know I've probably just harped on a lot more about good faith, but it is essentially the basis of our employment law and how we are supposed to deal with employers and employees. And I do want to stress here that it extends both ways. Both parties have a requirement to act in good faith. So what's the first step? Pretty simply is just formulate what you need to do. So you're going to have a pretty clear idea. You're going to hopefully have got some advice from your accountant or a business advisor or a lawyer in terms of formulating what is it that I need to do in my business, whether that's to save money, be more efficient, etc., etc. As Jane said, just because we're in the middle of a COVID pandemic doesn't mean that our employment law has gone out the window. These things still apply no matter whether we're today or in 6 months' time. When you are proposing a restructure, you have to have a really valid business reason for doing that. Primarily, most of the ones that I sort of see across my desk is it's simply about having to save some money or reducing labour costs to a more consistent or a lower, I've lost the word, but basically it's about I'm spending too much in labour costs, I need to cut that. So the first thing is formulating what you need to do. The second step is consulting with your employees on that. So Jane touched on that really well before. We want to write to our employees and we want to tell them what's going to happen. The best way of doing this is to invite your employee to a meeting and then lay out to them what is in that letter, as opposed to sending, hey, here's a surprise email that you didn't know you were going to be getting. So invite your employees in. Remember that throughout this process, an employee has the right to have a support person or a representative with them. So make sure you afford them that opportunity. And why that's really important if you are proposing a change, that you invite them to a meeting and enable them to bring somebody with them. Right now, we're in a really emotive time. And one thing that's really struck me over the last 5 weeks is we are all in the same situation, but the way that we are responding to that situation is very different. So for example, myself, I've been working from home. I actually feel like the last 4 weeks have gone quite quickly, and I've enjoyed my time with my family. However, there are some people out there that are chomping at the bit to get back to work, either because they can't bear to be at home anymore or they really need the cash because their wages, for whatever reason, right through to people having a real sense of anxiety about going out and working when we still technically have a COVID virus in the country. So we all have a really range of emotions. So it's really emotive. And that's why, as Jane said, here is a time where you're going to probably have to spend a little bit more time talking and listening and giving them the time to consider what this proposal you're making may mean to them. Consultation right now might look a little bit different too. So normally you absolutely meet with your employee face-to-face. However, right now in a lot of cases you can't. So consultation has had to be a little bit wider right now. Obviously we can use Zoom, Google Hangouts, Microsoft Teams, etc. Those are some really great face-to-face Zoom video conferencing ability. The telephone is also really useful during this time. And from next week, obviously we do move to level 3. So if you are a business returning to work, that may enable you to have that face-to-face back, but with obviously physical distancing. But consultation right now does look a little bit different than what it would do outside of COVID. So once you've consulted with them, you're basically giving them a window to feed back their responses or alternatives that they might be wanting to put forward instead of their position. So what might be an alternative? You might be proposing that you're going to say you've got a team of 10 and you're deciding that we are going to propose to take away 2 of those positions, disestablish them to save some labour costs. And so your team might come back to you and say, oh, well, actually, instead of that, to help those people keep all the positions, we're all prepared to take a pay cut, for example. Or someone might come forward and say, oh, look, I'm nearing retirement or I want an early retirement. So I'll take it as an alternative. I'll take retirement so that one of those other people can keep them. So that's an alternative. There might also be some ideas that people have around other ways that you can save money as well. So you have to consider all of those alternatives and responses. I know it's really hard in some cases because you might, as an employer, feel that you have no other option. But I've actually seen some really great suggestions come forward from employees in these situations that the employers actually thought, I never really thought about doing that. So it's really important that you act in good faith. Both parties keep a really open mind about what other alternatives there could be in the situation. But ultimately, after you've considered those alternatives and responses, you reach a decision. It's really important that you can clearly show what that decision is. So why have we chosen to make this decision? Why is this the decision that we have come to? And why perhaps do those alternatives and responses that we've had not achieve the same outcome that we need? So that is obviously another written letter that goes to your employees and another meeting to explain that to them. I can't emphasize enough that communication is key throughout all of this. This is a really stressful time for both parties without the COVID blanket hanging over us. I've got selection process there because sometimes, like I said before, if we've got a team of 10, say they're all full-timers, and you're deciding to establish 2 of them, you need to decide how you're going to decide which 2 go. So further up back, when you consulted with your employees about what you were proposing to do, if this was a situation that you're going to end up in, that you have to pick people, you have to explain to your employees how you will be picking those 2 people out of 10. There are various, I guess there's mainly sort of 2 ways that people tend to do this. One is the old, which is quite a traditional way, which is last on, first off. Sometimes that doesn't work in a business, and so we have to move into what's called an internal recruitment process. So basically we are recruiting for those 8 positions from that team of 10. So you need to have some really clear criteria in the process you're going to work through to pick essentially, or recruit internally the people that will be remaining. So you can see in that situation that there's kind of like 2 waves here for your team. The first wave is, okay, we're making a change, then we've reached a decision, and there's a second wave for those guys, because all of a sudden it's like, okay, well, they've decided that, but actually who is actually going? So that's a very much a second wave of emotion, and for again both parties. Obviously, the last point of the process is your notice period. So that's very much governed by your IEA, and there generally is a clause in your IEA about what the notice period will look like for a redundancy. So a redundancy, the definition of redundancy is when essentially a person's position is established and they are therefore redundant for the business. So 2 really separate terms when it comes to restructure redundancy. So in terms of this flowchart, the restructure is sort of the top line, and then the redundancy is kind of that bottom line, because that's your notice period for those people. Again, I'm just going to emphasize really strongly that good faith and communication in this is so important, especially during a time that we've got with COVID. But employment law does still apply, so quite important to make sure that we are carrying that on. I'm not sure if there's anything else you want to add to that, Jane, in terms of anything that you think I've missed.
No, Jane, it's fine. I'm happy. I'm just thinking now that we've got 3 questions that came in advance of the webinar, and 1 question that's been asked during the webinar. So if I can answer the question that's been asked during the webinar, which is, if employers are trying to act in good faith, but employees are digging their heels in, what can we do as employers to keep on track? Obviously, we need to be making sure that these answers that Jane and I are giving are general answers, so we can't answer anything specific. But in terms of the digging in their heels for employees, I guess the first question is, making sure that people are being communicated with in an appropriate way. So, for example, I've been dealing with an employer this week whose employee has no access to internet. And so that makes things obviously a bit more difficult in terms of the COVID situation, because ordinarily perhaps an email might be sent with the details of the proposal. So in terms of the employee digging their heels in, I just guess first that the communication is key. And Jane said during her presentation that picking up the phone is crucial. Giving your employees a ring and saying, hey, just touching base with you, I want to have a chat with you about a process. Is there some other way that we can catch up? In terms of the digging their heels in situation, I guess the other question that you need to be asking is, does the employee need any more support in terms of the process that they're going through? Have they got enough support around them? You'll know your employees better than on people on the external. So do they need somebody to talk to? Is there a counselling service, or are they engaging with their family members as part of this process? So it may be just looking at externally at all of the factors in terms of your employee's situation. And as Jane and I have both touched on, this is a really stressful time for a lot of people, and it's about handling things and trying to work out how best you can help your employee through this process. So one of the other questions that was asked in advance of the webinar was, just bringing it up on my screen. I'm wondering what the first step is if employees refuse to make contact about if they are returning to work. There's some more specifics in terms of that question, which I'm not going to go into, but in terms of that answer, if employees aren't responding, then the answer that I've just given in terms of communication is key. There's a lot of legal court decisions in terms of communication, and that the field that is in terms of abandonment of employment generally, but in this case the same principles apply. So the courts are really clear that you need to try all forms of communication with your employees. So that's email, text message, telephoning, and in ordinary circumstances that would actually be physically delivering communications to their house. So if the staff aren't engaging, then and you've tried all forms of communication, then you need to try those forms of communication and provide very clear timeframes. So if an employee if you're saying to the employee, if you don't provide an answer to me by 5 p.m. on a date, and that date needs to be, say, 48 hours time, then we will make the decision without your feedback, but we're recording that we have provided plenty of time and opportunity for you to give that feedback or response. Another question that's been asked before the webinar is, the business I work for is having its budget cut, forcing restructure and redundancies. I'm awaiting more info on the details, but that is the topic I'm most interested in hearing about. A couple of things. One, the good faith grey area will be interesting to hear more about, but also if my employer wanted to keep my role, can they change my hours or my pay rate as they wish? Now, I hope to that person that asked that question that Jane and I have, as best we can, answered that during the webinar.
So in terms of changing hours and pay, etc., you're looking at the same structure that I've just spoken through in terms of restructure redundancy, if there's no mutual agreement. So in this situation, the focus should always be on trying to mutually agree a change with your employee in that communication. But fundamentally, the steps on the screen are the same, because that sort of falls under that restructure umbrella. Yeah, so same steps, just slightly different proposal.
And there's another question that we received before the webinar. Again, I won't go into the specifics in terms of the situation, but the general question is, how do I fairly and legally tell my staff that once the wage subsidy runs out, I cannot afford to pay them and keep company afloat, so I'll have to make them redundant. So again, the same process that Jane's been through in terms of restructure redundancy, and the process that's still on the screen is important. And if you are going through a redundancy, I can't stress highly enough that you need to take specific advice in terms of your situation. So that advice needs to be in terms of the financial ramifications from your accountant, and also in terms of legal ramifications from your solicitor, or alternatively your HR advisor. Because the last thing that any of you as employers will want is a personal grievance in the circumstances. And because you haven't followed the process correctly, and you haven't provided sufficient information, time, or consultation process as is required by the law. I think I've just seen another question pop up on the screen as we've been talking.
Is there any process or precedent for establishing notice if there is no IEA? Into that one, Jane?
Yeah, so in terms of if there's no individual employment agreement, the general rule of thumb would be that the notice period would be a pay cycle. But the problem that you're going to have if there's no individual employment agreement is being able to agree on what that notice period would be. Again, it's another reason why it's so crucial to have an individual employment agreement, and why the law requires you to have one. And so it's going to be a bit of give and take between the employer and employee in terms of what that notice period would be. I hope that answers that question for that particular person.
Yeah, it's just another one that's also just come through here as well. What if an employee does not agree with the changes, even after going through the process? I'm going to take that from an employee perspective in terms of answering. Unfortunately, many employees don't necessarily agree with the decision that gets made after a restructure process, or can't fully, I guess, understand the why, which is why there's such an emphasis on the employer to be really open and honest under that requirement of good faith. If an employee is really struggling to understand the process or the reason, that's probably a time where they need to go and seek some independent advice, or involve, as Jane said, involve a family member or a close friend or somebody to help them, I guess, understand, or go to those meetings with them. That is why we have the ability to have a support person present or a representative. But if you really, if an employee is struggling to understand or very firmly disagrees, then they do need to be seeking some independent advice.
Another question that's popped up on the screen is, if you know that at the end of the 12 weeks you are unable to sustain the staffing level you currently have due to the decrease in work, do you let the staff know now and start the process Jane identified, or do you wait until the 12 weeks is up? My answer to that question is probably prefaced by an article that I read by Tony Alexander, who many of you will know was the BNZ chief economist, and he had a long discussion about that in an article that was on the New Zealand Herald website recently. And his advice was, from an economic point of view, that you need to start the ball rolling now if you know that you're going to have a significant decrease in work, which results in you being unable to keep all of your employees. And the reason that we have made the suggestion in terms of having your accountant involved is that if you are having a situation where your redundancies is as a result of financial consequences, then the courts, from an employment law point of view, have made it very clear that if you're relying on finances, then you need to be in a position to show what the financial consequences are and what the financial ramifications are for your business, if and when, if that is the reason why redundancies are to occur.
Yeah, I agree with that. I think that I said to somebody yesterday actually that I think we are going to see a wave of this restructuring at the end of that 12 weeks. Because I think for some businesses, as we've waited to see what alert level we'll be back to in 12 weeks, might not be the alert level they need necessarily to resume a normal, or start moving towards a normal level of business. I think in construction as well, we may also see another, potentially see a bit of a ripple effect throughout the rest of the year to the project demand. But it's about good faith and acting honestly and openly. So I would agree with Jane in terms of her reflection on when you start those things. A really quick question too, actually, does the wage subsidy payment need to be shown or identified clearly on employees' payslips? Disclaimer, I don't like payroll. Ha! Probably the only HR person that might say that. I don't 100% know the answer to that question. I don't know if you do, Jane.
No, I don't. And it's also, I've had a number of questions around it because a lot of the payroll programs actually won't let you record it. So I'm aware, for example, that ACE payroll, you can't muck with the payroll system on there and try and show it on the payslips.
What I can do is I've taken a note, and I'll come back to you, the person that asked that question, and get you an answer on that by the end of the day. Cool. I'm just going to keep moving for the moment because I know we are sort of running short on time. We just have a couple more poll questions, I think, that Janice is just going to throw up for us.
Can I just interrupt? Jane, there's an answer there that's from an accountant that's just responded saying that as far as he's aware, there's no requirement to show this separately on payslips, but as Jane said, she's happy to go back to the person that asked the question and just clarify that. And thank you to the person that's responded and said that Xero allows you to show the subsidy on payslips.
Cool. Thanks, everybody. So, Paul, are you planning on changing your employees' hours or pay during level 3 or level 2? So it was just kind of an idea of, again, another yes, no, totally anonymous, just following on from the restructure, just kind of getting a feel for how many people may or may not be doing that. I think Dennis will leave that out for another sort of 30 seconds. While you're answering that, I'll talk a little bit. I'll talk a little bit about alert level 3 at work in terms of a health and safety perspective. I will just say, as I know we are sort of 45-minute mark, I have over on our compliance partners Facebook page, there are 2 Facebook live videos that I've done this week talking about exactly that, alert level 3 at work. So I'll run over some basics today, but if you want some more in-depth stuff, there's 2 lives on our compliance partners Facebook page. You're more than welcome to watch. So we're about a 60-40 split again in terms of no, not planning on changing, or yes, planning on changing. Cool. So I'm just going to move on to alert level 3 at work. So I want to sort of open this with a little bit of a mention about mental health, and I kind of touched on it before. There are a lot of people that are going to be going back to work next week, and a lot of people are going to be very much on that spectrum in terms of how they feel about going back to work. I know as a business owner, there was a bit of a sigh of relief when Jacinda announced we were moving to level 2, especially I can imagine, not full breath of relief, but a lot of hospo would have been thinking, okay, good, we can resume some sort of level here. So as a business owner, you might have had a real breath of relief. There are still a lot of businesses out there that wouldn't have had that breath of relief because they have to wait to alert level 2. At the same time as you having a breath of relief and being geared up to being back into it. As I said before, a lot of our employees are going to be on that real spectrum of emotion, from anxiety to happiness, to grumpiness in some cases, and also a smattering of grief. I remember reading an article in the first week of level 4 of a logging truck driver in Northland who said this is the first time in his children's lives that he is able to spend time with them at home for such an extended period of time. So for some people, going back to work is going to be a bit of a grief struggle. I'm going to be really honest and say the thought of setting my alarm for 5:30 and having to get my children to school is not filling me with joy, and it's going to be quite a struggle to get back into. So even people that want to be back at work or have been working from home over this period are still going to have a bit of a struggle. So I just think we need to be mindful of that as we move through, not only from employer-employee perspective, but also amongst employees as well. I was in the supermarket yesterday. I overheard a woman talking to one of the staff to say how, you know, the woman at the supermarket was saying how grateful she was to have a job. And the lady, the person talking to her, her response was, yeah, I don't have a job anymore. So even if we might be back at work with our workmates, they might still be having some stress at home if their partner or husband or wife have lost their job. So just be mindful of that. We have a really great resource in New Zealand, 1737. It's a free number that you can text or call 24/7 to get access to a trained counsellor. I actually read an article last night that over the alert level 4 lockdown period, that 1737 number has had over 1,700 calls or texts from people struggling with their mental health during this time. So a really good number to give out to your team or your employees to sort of help them if you can. So basically, when we're going from alert level 4 to alert level 3, we're having a focus. We're moving from essential work to safe work. And so we need to be focusing on keeping our physical distancing, recording who is working together, limiting interaction, and disinfectant and surfaces and cleanliness, and also maintaining our high hygiene standards. So that's a really key term for you to think about. We're moving from essential work to safe work. I've had a couple of people say to me this week, God, level 3 is harder than level 4. And it is, because under level 3, we have more people moving around in our workforces. And COVID strive, like any virus, it thrives in a close proximity or dense population. So the sooner we go back to that, our risk goes up. So level 3 is going to be a little bit harder than level 4 for those of you who've been working through. So even those of you who've been at level 4 working, under level 3, you might need to put some additional things. Actually, you probably will need to put some additional things in place. So the key things to think about are basically what I've put into that little bullet point there. Physical distance. I just realised a spelling mistake in my slide, how terrible. So it should be focusing on keeping physical distance between work. So the 2-metre golden rule applies. There is a little bit of a bandied round in the construction industry in the last week around a 1-metre rule. There is that ability if you absolutely have to, but 2 meters is still your golden number. Contact tracing is really important under level 3, and it will probably remain important under level 2 and level 1. So contact tracing is recording who is working together, who is traveling together. Basically, if I was to come to you tomorrow and say, hey, Bob, your staff member, tell me every single person he came into contact with in the last 48 hours, you should be able to whip that out and tell me all the people that Bob came into contact with in the last 48 hours. That includes people coming to your workplace as well. Every contact can be traced is the idea. We do need to keep limiting interaction. So I had one question this week, bless them. They said, the employee asked, since we're going to be in a work team bubble now, can we have drinks after work? Level 3, unless you're at work working, exercising, or at the supermarket, you must remain at home. Okay, so that's no different from level 4.
So the answer to the work drinks is no.
Yeah, they can
do
drink,
it via
but
Zoom like we are every Friday night. It's great fun.
So just because we're going back into these team work bubbles doesn't mean that it is business as usual or drinks as usual on a Friday night. So really important for the your team and you to understand that unless you're at work, the supermarket, or exercising, you are at home. Okay? You can do a little bit more under that recreation and exercising in level 3, but essentially level 3 is quite similar to level 4. Disinfecting and hygiene are really important. So you will need to have some sort of cleaning schedule. in place for cleaning your surfaces and your tools and your equipment, and you'll also need to be really educating your team around how to do that. High hygiene standards, exactly the same as what we had prior to going into level 4, which is around hand washing, hand sanitizing, and having all of that set up on site. Remember, hand washing if your hands are dirty, hand sanitizing if you're unable to access water and soap. You can hand sanitize, but if your hands are dirty, you really should be washing them. So you might use hand sanitizing, for example, if you've got a delivery coming in, you need to help the delivery driver unload it. So you might put some gloves on, so you'll hand sanitize before, put your gloves on, assist the delivery driver with your 2-meter distancing, take your gloves off, hand sanitize, off you go. Versus I've worked all day, now it's lunchtime, I'm going to go and eat my lunch. That's when you're going to wash your hands. So just a slight difference there. There are obviously going to be some real changes to the way sites and workplaces work going into level 3. So it's really important that you do a reinduction before you have everyone back to work to help talk them through the rules. The other thing that's going to be a little bit tricky in a level 3 for some places is your eating and break arrangements. So meal breaks need to have that stagger, need to have that physical distance. And I personally am encouraging from our clients to encourage their workers to be bringing pre-packed lunch boxes to work rather than nipping away to do dairy shopping, etc. In their breaks. And then essentially it's just about your team bubbles. So how are you educating your teams, or how are you dividing your teams to work in the smallest bubble as possible? And how are you making sure that interaction between bubbles is kept to an absolute minimum? But those are kind of your key things for alert level 3 at work. As I said, way more detail in the 2 videos over on the CP Facebook page. I don't know, I'll ask Janice if there's some way that we can perhaps link to those as well for you. But that kind of brings me to the end of really alert level 3 at work, which also brings Jane and I to the end of our little session. I know we've gone a little bit longer, so apologies, but hopefully you have all got something useful out of this morning. I can't see any more questions that have popped up. I'll just grab it. I'll give you more 30 seconds if there was any other questions that anybody had to drop in. Otherwise, that's our info today. We do have a couple of last polls, so maybe while we wait to see if anyone wants to pop up any more questions, Janice could just pop up the last couple of questions for our polls. So are you planning on operating during level 3? Yes or no? So I have actually heard of some companies that are waiting until level 2 to start operating, not necessarily because they have to, but because they've just made that choice. Because remember,
and the other person, it was interesting. I heard Simon Galt, the chef, interviewed on Radio New Zealand yesterday afternoon, and he was saying that he wasn't actually thinking of opening his restaurants until he got down to level 2 in any form, because he was simply saying, well, nobody goes to a half-full restaurant, and nobody goes to a restaurant where there's only a couple of people, and so therefore I'm not going to open my restaurants at all until it's safe to do so in a full capacity, which I thought was interesting from somebody like him.
So about a 70-30 response on that. 70% yes, they are planning on operating, and a 30% no, they're not. I think there might be one more. Correct me if I'm wrong. And last question, do you feel prepared for level 3 requirements? If you say no, I'll be like, oh, no. But yeah, do you feel prepared for level 3 requirements? I will say there's been a lot of information out there. If you're a tradie in the construction space or you're going to construction sites, Chasms has done an amazing piece of work with Site Safe, government, and a lot of other big players in the construction space regarding I guess a bit of a standard and protocol for on-site. It's a fabulous document. You can find that on the Chasms website. I'd really encourage you to go and have a look at that. And the due for prepared 92 to 8%. Yay! The 8%, if I can help in any way, please feel free to get in touch with us. There's a question that's just popped up, which I'm going to just pause around support needing to restructure in terms of cost for that support. That is quite a hard question to answer, I'll be honest. Jane might have a different answer, but it really
I'm happy to go back to the particular person that's answered that question.
Yeah, we'll just come back to you. I'll make a note down about that as well. And the other one is, I've heard a lot of people getting paid just the $5.85 and nothing else. What can they do after to get what they are owed? That would depend. That's another question that's probably quite situation specific. I think that if that person has some concern that they haven't been paid appropriately, they probably need to be going and getting some independent advice about that. Cool. I think that's us. Janice is giving me the wave of it's over, team. So,
the other website I was just going to say that's fantastic resource is in light of tomorrow is standatdawn.com, so that you can still recognise that tomorrow is Anzac Day. And I can't speak highly enough for the fantastic resource that the RSA and the New Zealand Defence Force have created. It's also got lots of great kids activities, which I've been getting my kids to do. They're fantastic.
Very cool. Thanks so much, Jane and Jane, for your time and sharing your knowledge and views in this webinar for the benefit of the community. Thanks also to those of you who tuned in. I hope that you learnt some useful information. All businesses and all HR situations are encouraged to contact their own professional advisors for specific advice. Unless you have a question for Jane and Jane, please go to them directly. We will send you a survey link in a day's time. Also provided in that email will be a link to our Ashburton District Council webinar series, so you can watch it on demand. This webinar series is something that's continuing to grow, so please keep up with new webinars as they become listed. And those will be listed on the Ashburton District Council Facebook page, so you can see what is coming up. Thanks again, and stay safe in your bubbles.
Thanks, everyone.
Thank you.
Thanks.